Mr. Deputy Speaker, sir. I am grateful to the honorable member from Nongkrem Assembly constituency, Shri Arden Miller Basai, for having raised this resolution for discussion in this autumn session 2023 as follows. This House do now stop this gross violation of the Meghalaya Transfer of Land Regulation Act 1972. Sir, Meghalaya was established as the 21st state of India by the Northeastern Areas Reorganization Act 1971, bounded in the north and east by the state of Assam, south and west by the country of Bangladesh. The new state of Meghalaya on 21st January 1972 comprised of the United Khasi, Jaintia Hills District and Garo Hills District. Sir, alienation of tribal lands is a very sensitive issue, and the government of Meghalaya, since the inception of the statehood, has tried to tackle it comprehensively by enactment of the Meghalaya Transfer of Land Regulation Act in the year 1971. The purpose of enactment of this act is to regulate transfer of land in Meghalaya for the protection of the interests of the scheduled tribes of the state. The act came into force in the year 1972. The Meghalaya Transfer of Land Regulation Act 1971, Meghalaya Act 1 of 1972, extends to the tribal areas within the state of Meghalaya as specified in Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution, subsection 2 of section 1. With the enactment of this act, land in Meghalaya, which includes immovable property of every description and any rights in or over such property cannot be transferred by a tribal to a non-tribal or by a non-tribal to another non-tribal except with provision sanction of the competent authority, and any transfer of land made in contravention shall be void and shall not be enforceable in court. Sir, the Act has various provisions which fulfill the intent of legislature when it was enacted, and I would like to highlight some of the important provisions as follows. Section 3, it mentioned that no land in Meghalaya shall be transferred by a tribal to a non-tribal or by a non-tribal to another non-tribal except with the previous sanction of the competent authority. The section was further strengthened by an amendment as early as in the year 1973 by Act 1 of 1973 by adding a proviso which stated that, provided that the government of Meghalaya is satisfied, may from time to time by notification prohibit any transfer of land within such area or areas as may be specified in the notification, and thereupon the competent authority shall not sanction any such transfer of land under the provision of this act within such area or areas. During the course of time, this section was further amended by the legislature in the year 1991, Act 11 of 1991, which added another proviso which stated that, provided further that no notification made under the preceding proviso shall apply to transfer the land for any of the purpose mentioned in Clause E or Clause F of the subsection 1 of Section 4. Therefore, sir, the two important exceptions allowed by amendment of 1991 are, number 1, Section 4(1)(e), whether the land proposed to be transferred is required as a place of public religious worship by any community or as burial or cremation ground. 2, sir, Section 4(1)(f), whether the land sought to be transferred is for the purpose of implementing a scheme to promote in the interests of the tribals in the field of education or industry. Section 4. This section lays down in the details the procedure to be followed in any matter of the transfer of land. It mentioned that in granting or refusing sanction under Section 3, the competent authority shall take into account the following matters according to the circumstances of each case. A. Whether the non-tribal holds any other land in Meghalaya. B. Whether there is any other tribal willing to take the land on transfer at the market value. C. Whether the non-tribal seeking to take the land on transfer is carrying on any business, profession or vocation in or near the area, and whether the purpose of such business, professions or vocation, it is necessary for him to reside in the area. D. Whether the proposed transfer is likely to promote the economic interests of the scheduled tribes in the area. E. Whether the land proposed to the transfer is required as a place of public religious worship by any community or a burial or as burial or cremation ground. F. Whether the land sought to be transferred is for the purpose of implementing a scheme to promote the interests of the tribals in the field of education or industry. This section also mandates the competent authority to record its decision in writing along with the reasons thereof. Mr. Speaker, sir, at this juncture, I would like to highlight that since the enactment of this Act, certain exemptions which have been put under Section 11. This section contemplates that nothing certain in this Act shall apply to A. Any transfer of land as security for any loan granted by such banking company, cooperative society or other credit institution as the government of Meghalaya may by notification specify in this behalf, provided that a banking company, cooperative society or other credit institution as notified above by the government of Meghalaya shall not transfer any land to a non-tribal except with the provision with the previous sanction of the competent authority as provided in Section 3. B. The letting out of rent of any building standing on land. C. Any transfer of land to or in favor of government or district council. D. Any transfer of land to or in favor of, number 1, any company, cooperative, corporation, society including cooperative society, autonomous body or association, wholly or substantially owned and controlled or managed by the government and which the government of Meghalaya may by notification specify in this behalf. 2. A municipal corporation, municipality or town committee constituted under any law. Sir, the government of Meghalaya in the Revenue and Disaster Management Department regulates various applications on matters relating to, number A, sir, transfer of land which include gift, sale, exchange, mortgage, lease, surrender, will. B. Change of land use of leased land. C. Inclusion of deletion of names in the lease documents of the leased land. D. Regularization of excess area of the leased land. E. Settlement or allotment of land, of government land. The government has put in place various safeguard mechanisms to ensure that the provisions of the Act are followed stringently. Some of them are as follows. The notification dated 7 June 1978 prohibits transfer of land by a tribal to a non-tribal or by a non-tribal to another non-tribal within the areas specified below. 1. The area within the East Khasi Hills district except the area to which the act aforesaid does not apply. 2. The area within the Jainti Hills district. 3. The areas within the West Khasi Hills district. And number 2, sir, the notification dated 2nd February 1979 prohibits transfer of land by the tribals to non-tribals or by non-tribals to another non-tribals within the areas specified below. Number 1, the areas within the West Garo Hills district except the areas within Moza number 6. Number 2, the areas within the East Garo Hills district. 3, sir, allotment or settlement of vacant government land for private purpose will no longer be considered as per Office Memorandum number RDS 28/92/27 dated 24th June 1998. Renewal of lease and enhancement of land revenue for government land lease to individual has to be renewed after a period of 30 years as per Office Memorandum number RDS 69/87/25 dated 25th January 1988. The procedure to be adopted for revenue plots by way of lease agreement in which the departments, while processing any case, abides by the Meghalaya Transfer of Land Regulation Act 1971 and Meghalaya Transfer of Land Regulation Rules 1974 has been clearly indicated in instructions issues white letter number RDS 53/86/PT/91 dated 20th June 1998. For transfer of government revenue land, government to lease, Rule 4, 5 and 6 of the MTLR Rule 1974 and direction of government in the revenue department from time to time are followed by the competent authority while processing any application of land transfer. For transfer of land from tribal to non-tribal, especially to companies, Rule 4, 5, 6 and single window agency clearance, concern to operate, concern to establish, NOC from District Council and local authorities, inspection report, maps, land documents, public notice, and directions of government in the revenue department from time to time are followed by the competent authority while processing any application of the land transfer. Clause 4, 5, 6 and 19 of the lease agreement issued by Deputy Commissioner specified certain conditions which are the number 4, sir, that if the land is utilized not for the purpose it was leased out without the permission of Deputy Commissioner, it will deem to be breach of the lease term liable to be determined under Clause 19 of the agreement. Clause 5, sir, that if the land is not put into use within a period of 10 years from the date of issue of lease, the government reserves the right to cancel the lease and to take over the land and dispose it of in the manner the government deems it fit. Clause 6, that on the said land being surrendered under Clause 5, the government shall pay compensation for the building and other structures, including trees planted and raised by the lessee at an amount as may be valued by the Deputy Commissioner. Clause 19, that on determination of the term of this lessee, his or her respective and assigned shall have the first offer of renewal thereof on terms to be fixed by the government, and that if such offer is refused, the lessee interest or that of his or her respectively, and the interests of anyone holding through or under him or his or her heirs, representative, and assigned as tenant, mortgage, or otherwise shall absolutely cease and determine. Mr. Speaker, sir, one important aspect of land administration in our state is that under Section 3 of the 6th Schedule to the Constitution, the management of land and forests also vests with the Autonomous District Council, which are empowered to make law with respect to land management and administration. These three district councils in the state of Meghalaya, namely Khasi Hills Autonomous District Council, Jaintia Hills Autonomous District Council, and Garo Hills Autonomous District Council, the respective district council, which under the 6th Schedule of the Constitution are empowered to make laws with respect to the land management and administration extra, have enacted respective legislation touching upon the basic land system of the areas under their jurisdiction. The Khasi Hills Autonomous District Council has enacted the Khasi Hills Autonomous District Council Regulation and Administration of Land Act 2021 with the objective of codifying and making provisions for the regulation and administration of land in harmony with the prevailing practice of land tenure system in Khasi Hills District without deviating from the existing customary practice. The judicial pronouncement of the Honorable Supreme Court, the objective of the aforesaid codification is to protect and conserve the land tenure system prevailing in the tribal areas of the Khasi Hills, to preserve the socio-cultural and economic characteristic of the Khasi society. The Garo Hills Autonomous District Council has enacted the Garo Hills Autonomous District Land and Revenue Regulation 1954, which deals with land tenure or ownership, including heritable and transferable rights, land selling, land assessment extra. The Jaintia Hills Autonomous District Council has enacted the Jaintia Hills Autonomous District Council Management and Control and Assessment and Collection of Revenue Regulation 1968 with amendments. Mr. Speaker, sir, the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013 also lays down certain safeguards to check the land alienation amongst the tribals in general. One of the purposes of this act is to ensure safeguard against displacement in consultation with institutions of local self-government by way of special provisions have been made for scheduled tribes under Section 41 and 42, which protect their interests. As per Section 41.1, as far as possible, no acquisition of land shall be made in the scheduled areas. As per Section 41.2, where such acquisition does take place, it shall be done only as a demonstrable last resort. As per Section 41.3, in case of acquisition or alternation of any land in scheduled areas, the prior consent of the concerned Autonomous District Council is necessary. The RFCTLARR Act 2013 also lays down the procedure and manner of rehabilitation and resettlement. In short, the Act provides that any land acquisition in the tribal areas of Meghalaya shall be done with the consent of the Autonomous District Council. In conclusion, sir, in view of the above mentioned points, it is clear that the government, while processing any case of transfer, mutation, mortgage, will extra, proceed as per the provision laid down in the Meghalaya Transfer of Land Regulation Act 1971, Act 1 of 1972, and the Meghalaya Transfer of Land Regulation Rules 1974. As of now, no such matter of the gross violation of the Act has come to the notice of the government, and I would like to impress that the intention of the government is very clear on the matter of transfer of land, and that the Act and rules are followed in the letter and spirit so as to protect the interests of the scheduled tribes of the state. I therefore request the honorable member to kindly withdraw the resolution. Sir, with this submission, I resume my seat. Thank you.
Mind of the mover, whether the honorable mover will withdraw his resolution.
So, can I get some clarification before I decide to withdraw?
Yes, please.
I would like to thank the Honorable Minister for his reply. And there are certain issues that I flagged during my submission, sir. And that is the purchase of land by other tribals, which is very rampant, especially as I've mentioned, in the southern part of the state. And because, you know, sir, human nature, they will try to find the loopholes. So what they are trying to do, because I have also brought to the notice of this House the observation of the Supreme Court as far as the rights of other tribal from one state in another state. So, which is clear that no other tribal from other state can get the benefit in terms of lands or any other benefits that the tribal of Meghalaya, pertaining to Meghalaya, are getting. So, since this is rampant, so may I request if the government can consider, because there is a loophole that these other tribals, they are trying to purchase land by way of getting a PRC, to prove that they are the permanent residents of Meghalaya. So it is very easy, sir, to get a PRC in Meghalaya. I have here with me the application form when anyone would like to get a PRC in the state of Nagaland. There are many particulars that the applicants will have to fill in this 3 pages form. Whereas in Meghalaya, they need only, through the office of DC Deputy Commissioner, only 1 page where only 2 passport size of photographs, birth certificates, residential proof like EPIC ration, certificates of all institutions. And there's no mention here about the role of the village Dorba. But when it comes to the application for PRC in Nagaland, it seems to be more stricter than Meghalaya. So, sir, I think if we can plug this loophole, we can prevent the alienation of land in our state to other tribal coming from other states. And so I would also like to, because in the course of his reply, the minister has mentioned about the role of the district council. So we have to understand that when it comes to the role of district council in transfer, the district council has no role as far as transfer is concerned. And this has been observed by the Supreme Court, that district council is not mandated to make law on transfer, only for management. So we are not here to discuss about the management of land, we are here to discuss about the problem of transfer. So, and since we are a full-fledged state, sir, we have to also understand that we cannot bring into all the provisions of the 6th schedule. Because when the government of India decides to give us a full-fledged state, on that very day itself, they have inserted para 12A in the Constitution of India, which is the overriding power of the state government. So therefore, we should not find excuse that this is the jurisdiction of the district council and we have no jurisdiction at all as a state government. By para 12A, this is an overriding power that the state government. Therefore, we need a uniform law throughout the state, sir. We don't have to have different legislation in different autonomous councils, sir. So, sir, my request for the government is that if the government can plug these loopholes as far as the issuance of PRC is concerned, they can make more stricter, because any tribal who wish to be the resident of Meghalaya has to, ready to sacrifice being the resident of his state, sir. So, sir, if I can get an assurance, because there are many ways of violating the Land Transfer Act. There is a practice that even power of attorney also is being used to transfer land from a non-tribal to another non-tribal, and from from a tribal to a non-tribal, sir. These are the two main concerns I would like to raise before the minister, and if the government can assure that they will look into it and make more stricter, then I'm willing, sir, to withdraw my resolution.
Sir, I'll just put some more light on the reply that was given by the Honorable Minister. So first, I just want to stress on the fact that the Honorable Member has been mentioning about violation of the Act, sir. So what we are stressing on in our reply is that there is no violation of the Act as such, because any violation of any Act, so the constitutional provisions are there for the judiciary to be approached. So therefore, violation as per se of the Act and the provisions of the Act are not there. People have used different provisions for different ways and means. That's a different issue. But the violation in itself of the Act is not there. And I'm not saying that it's been done. I'm just referring to the Honourable Member's statement which he mentioned. So therefore, sir, I think first thing we need to clear that the Act itself is not being violated. Provisions are there, and based on those provisions, different purposes have been served, whether it's the education issues or industries issues, in all cases where there has been an issue of a non-tribal or any organization coming in, it is based on the provisions which is very much in the Act, whether through the original Act or through the amendment. So that's the first part. So the second part is regarding ensuring that these entire issue of the PRC that has to come in. Sir, we are all aware, sir, for the purpose of land as such, so the PRC is not a document that is used. It is more, PRC is more for issues like education. In all these areas, the PRC is used. Of course, they may ask for the certificates and all. Those details are not with me as of now. But for purchase and sale of land is not done. PRC is not as such a document and is not really applicable in that line. But, sir, I think the concerns that he is raising, sir, we have noted, sir. And yes, there are different areas which is mentioned that there are concerns. And I think as a member in this August House and as a citizen of this state, obviously, sir, we all share those concerns. And definitely, sir, the suggestions made by the Honourable Member and including the other members also had participated. So we will note all of that down. We will examine all these areas, whether PRC is the right way to do it or whether we have to see the definitions in the things. So we can examine all those matters. But as I said, from the primary resolution that was passed, as I said, I would like to stress again that there's no question of any violation of the Act. But as I said, the suggestions made by the Honourable Member, concerns have definitely been noted. We are also obviously all concerned about issues when it comes to the rights of the tribals of our state. And definitely, sir, we will examine all those matters as mentioned and find the best way possible on how we could move forward in these issues, sir.
So, may I know the mind of the mover, please?
Sir, I think I stand by what I've stated in this house, sir, that there is a violation. I don't know why the government is in the denial mode. So many people are purchasing land in Ribhoi district. Those who are not supposed, to be covered by the Land Transfer Act. And I have a copy with me also. These are the people who have purchased land. So many people who have purchased land. So therefore, there is a violation of this Meghalaya Transfer of Land Regulation Act. I don't say that the government is violating, but the people, how can they purchase land when they are not a tribal pertaining to Meghalaya? And that is rampant in Ribhoi district. So I stand by what I've stated, sir. But I also like to express my thanks to the government for willing to examine the points that I've raised. So, sir, therefore, to say that there is no violation of land transfer act in Meghalaya is, I think, is ill-informed is not correct, sir, on the part of the government. There is, sir. I have copy with me also. I can even provide this copy to the government, sir.
So you are withdrawing? Or?
Yeah, I want to hear from them.
Sir, I have just like to read the provisions in the Act itself, where it defines tribal. It means a person belonging to any of the scheduled tribes pertaining to Meghalaya, as mentioned rightly, and as specified in the Constitution Scheduled Tribes Order 1950. And hence, sir, it is based on this particular definition that are there. But as I said, sir, the lands that have been transferred as per the provisions that are there in the Act itself, under those circumstances, I'm saying the violation is not there. Because, sir, if the violations are there, obviously, sir, for any violation that happens, the court and the judiciary is there where any citizen can go and seek justice, saying that this particular law has been violated. And hence, this kind of case we have not seen, and in any of the situations where cases have been put forward, in those cases, the court has given orders, and wherever the court has given orders, the state government has then implemented those orders based on the court order. So I'm saying it from a pure judiciary and constitutional and the law point of view, sir. Whether the principle or the purpose of the Act is not being implemented and concerns being there, sir, yes. I'm not trying to say that there are no concerns, but purely from the Act point of view and violation point of view, because if there were violations, sir, any individual is free to go to the court, is what I'm saying. But nonetheless, sir, I just want to clarify that part. So therefore, if there are any concerns like this, sir, everybody is free to go to the court, and the court, obviously, whatever verdict the court gives, it will be implemented. But to look into it and examine on how we could strengthen it or change things, that's a separate subject, sir. So therefore, that part, as I said, we will definitely examine that matter, sir. But my stand in the point of violation is not in terms of the principle or the purpose violation, but in terms of the legal violation and the constitutional provisions and the provision of the Act that is there. In that terms, sir, the violation is not there, because the procedure has been followed. Otherwise, court would have come in, anybody would have gone for a court case, and there would have been an order from the court. So from that point of view. But from the principle and the purpose point of view, sir, as I said, the concerns that he has raised are there, and we will definitely, sir, examine this and figure out how we should move forward, sir.
Sir, I'm still not satisfied as far as those, since I've raised these issues specifically for those people who have purchased land in Ribhoi district. So what will the government do? Because the definition itself explained about the tribal pertaining to Meghalaya. And it is this very definition that some people are trying to misinterpret, by citing that any tribal which is there in the tribal list of 1950. But the Act itself speaks about the tribal pertaining to Meghalaya, which means only the Khazis, Garos, Kashri and Rabhas has access. So, sir, what will the government do in order to prevent, to stop that the purchasing of land in the Ribhoi area?
Yes, so I'll just read out the line again. Tribal means a person belonging to any of the scheduled tribes pertaining to Meghalaya, and there's an and to it, and as specified in the Constitution Scheduled Tribe Order 1950. So the provisions are very clear, and based on these provisions, whatever is happening is happening. So the violation, as I said, if there, anybody is free to move to the court. So I want to segregate these two parts. So violations, sir, as per the provisions in the Act as of now, are not there. There's no violation. Otherwise, as I said, if there is violation, please can move to the court and court can take. Regarding reviewing it and looking into it and examining the whole purpose, I've said that I will definitely examine the matter and see what are the areas that are there and look back into it. But that is not part of this resolution as such, because it's talking about the current Land Transfer Act. If the resolution had mentioned specifically that amendments and this resolution resolves to amend the Act in this manner, then we could have discussed that aspect. But as I said, the violation. So I'm trying to be very, very particular with the words that have been mentioned. I am not saying no to the examinations. We will definitely examine. We have noted the concerns and we will see how to move forward. But whatever has been done right now, sir, is as per the provisions that are laid down in the Land Transfer Act, sir.
So, sir, I think when we read about the provision of the law, we have to also understand that we need to read between the lines. We need to read between the lines. When the definition about the tribal means a tribal belonging to any of the scheduled tribes pertaining to Meghalaya, then who are the tribes pertaining to Meghalaya?
And as specified in the Constitution.
Yeah, and I will come to that. And specified. And I have already explained what does it mean by specified. Specified is a past tense of specified. That means to describe or explain something, clearly and exactly. That means this, the list of scheduled tribes or the 1950. That means the Khasis and the Garus have been included, specified in that list. It does mean that all those tribals enlisted in the list will be, is pertaining to Meghalaya. If we take in that line, that means we are wrong, so we cannot rectify. So we have to understand that when that word unspecified, it's being specified in the list, which means the Garus and the Khasis has been specified in the list, not any other tribes coming from other states. That is where, people have been misinformed, misinterpreted, that they are getting the benefits on land even in Meghalaya, which is not right if we go according to the observation of the Supreme Court, sir. So therefore, sir, we have to read between the lines in this portion. It means the list and specified. That means clearly explain and describe in the list, which means that the Khasis and Garus are included in that list. So we cannot take all those tribes in the list to be pertaining to Meghalaya. That is my contention, sir.
So that's the interpretation that the court will have to do. I think for us to say that we'll have to read between the lines, that's not how the law will work. As I said, if there are concerns about this definition of this, the court can be approached. But that is something that I don't want to comment on, because as I said, interpretation can be done in the court, and anybody here has any grievances can definitely approach the court. But as I said, the concerns that he has raised, we can examine those concerns.
So, finally, what is the mind of the mover, please? Whether you wish to withdraw or not?
So, this is a very serious issue, sir. And we have, as I've told, that we have lost large tract of lands in different forms. So I'm very, concerned that if we don't put a stop and if we don't do anything, maybe the government can issue a public notice as far as the interpretation of this, the word tribal is concerned. So I'm not, satisfied, so therefore, sir, I beg not to withdraw.
Okay. Since the mover has not withdrawn his resolution, I will put the question before the House. The question is that those who are for the resolution say aye. Those against say no. The noes have it, and the resolution is lost.